Good morning, Mr. Redgate.
Good morning, Your Honor.
You may.
May it please the Court, I'm Russell Redgate on behalf of the defendant, Michael R. Brown. And on his behalf, I brought essentially two issues to this Court. Each in turn, of course, spawned some subordinate issues. But one of the issues I think is far more academic interest. It's in some sense a glamorous issue, federal preemption and supremacy principles, the nature and the reach of Article 14, the nature of these combined task forces, but it's of very little importance as a practical matter to my client. It would leave his position essentially unchanged if the Court were to rule favorably. It would not affect any of the indictments upon which he was convicted at a July jury trial. On the other hand, the more pedestrian...
So why would we want to reach that issue?
Excuse me, Your Honor?
Why would we want to reach that issue? You're talking about the one-party wiretap?
Yes.
It affects the jury waived conviction, right?
It does, yes. There was a jury waived trial in September, and that issue, which had been presented to the Court as a suppression issue, was preserved. That was really the purpose of a jury waived trial, which was, for all intents and purposes, a guilty plea, preserving the right to litigate that suppression.
Before we leave that point, why was that interception not lawful under Chapter 272, Section 99B4?
Well, I think that's the way it was held in the trial court.
No, but wholly apart from the presence of a federal agent, you don't even, I mean, wholly apart from that exception, why was this not an interception for an investigative or law enforcement officer to record and transmit if the officer is a party to the communication and has been given prior authorization to record or transmit the communication by such a party? Just why is it?
Because the law enforcement officers were not parties to the conversation. It was a
no, but it includes if the officer is a party to such communication or has been given prior authorization to record or transmit by such a party. So somebody can wear a wire if if the person agrees with the police officer to wear a wire. You can wear a wire unless you are in the home of the defendant, which we were not. So are you saying that blood extends to include somebody else's home?
Yes, I think it does. And I think that was the...
Do you have any case which has said that the constitutional limitation we impose under Article 14 in blood applies when a person is recorded in a home which is not of the defendant's home?
I think just the language of blood itself that refers to the home and the nature of a home and the way that citizens feel more confident of being protected from government intrusions there. I don't think I have a separate case. Blood is the case.
But it seems as if you're not only asking us to challenge the finding of the trial court as to whether or not the federal authorities were instrumental in doing this recording, but you're saying that blood now applies to any home, even if it's not the home of the defendant.
Well, again, the trial court didn't rule on that, but the trial court certainly tipped its hat in that direction, said there's much in blood to support the defendant's position. Nevertheless, the trial court said I'm bound by Gonzalez, which says it doesn't apply. So I say, yeah, it's of enormous academic interest. That particular issue that Your Honor just pointed out, that section, was not litigated in the trial court. Nobody raised that on behalf of the government to say, well, wait a minute, we could be okay under this section. It was simply under the federal exemption, and that's what was litigated. So, as I say, there's tremendous interest here. There's a lot of issues. But a favorable ruling from this court would matter but little to my client in comparison with the question of what does it mean to dispense and what does it mean to distribute.
If we can move then to dispensing, what do you say is a lawful user?
An ultimate user is the statutory definition, and it's someone who possesses the drug lawfully. So, in other words, if a physician who's licensed to write a prescription has lapsed, writes one nonetheless, then the patient who fills it they say would be a lawful possessor, although the physician would not have lawfully written the prescription.
Okay, how about if the doctor prescribes medication, but did so outside the standard of care and never should have prescribed the medication?
Same thing. If the patient is not complicit in any way, for instance, there's no indication in the recent Coburn case, which was brought to the court's attention in the appeals court by the Commonwealth. I don't think it's directly applicable, but it has some peripheral benefit. And there's no indication that the patient in Coburn did anything wrong. He simply he went to Coburn, then he went out to California. He continued to get the same prescription out there. He came back. Later, Dr. Coburn was charged with having provided that without a medical necessity. Later, he was acquitted in the appellate.
Let me just follow up on that. So if a doctor knowingly prescribes to drug addicts who are only interested in getting drugs, would you say they're an ultimate user?
They are not. If they're only
So a doctor can do that and not worry about being charged with dispensing?
Not with dispensing, no. He ought not to be charged with dispensing.
Does Section 19A state a crime for illegally prescribing controlled substances for a non-legitimate medical purpose?
That was a question raised at oral argument in the appeals court. It was not dealt with in the briefs as whether it's a freestanding crime, but Justice Drebin asked me that question, and I said, you know, that's arguable. It may, but it's not the crime my client was charged with.
I know it wasn't charged with, but
Right.
That's why I'm asking you
It
this.
may, but I think it's arguable. In the dissenting opinion that Justice Mills wrote, he referred to that Section 19 as I would have and said, look, if a physician prescribes without a good medical reason, he loses the exemption provided by Section 19, which is what 19 says. If you do that, you're subject to prosecution.
It also says you're subject to the penalties.
To the penalties.
To the same penalties that correspond to the drug that was distributed.
I agree that it's arguable.
Yeah, can't you read them together? I mean, that if you're prosecuted under, what is this, 32AA? Is that,
Well-
that it would, in the case of a doctor like this, it would bring in 19A?
You do read a whole statute together. I have to agree to that. But the defendant was charged under 32. He was charged specifically with the language of 32A, that he did distribute or dispense. Only dispensing went to the jury. At that fork in the road, maybe the Commonwealth might have second thoughts about that. But again, at oral argument, Justice Drebin asked me, well, what if it had been a distributing conviction? Would you still be here? I said, I'd still be here, but with a lot less confidence. I think it would be a better fit.
But one of the elements under Section 32B is the lawful user, the ultimate user. That's your argument.
To
dispense.
The way that you dispense.
If Section 19 is a freestanding crime, that element is not present in that crime.
I wonder then if, when interpreting that, if it were a freestanding crime and if somebody were charged under it, said you're now subject to the penalties of 32, wouldn't you have to look at 32 and say, what have you done under 32? I don't know. It's certainly another issue. I don't think that it's decisive in this case because there was no reference in the indictments to either the language or the section 19. It was strictly a 32A.
So what, I guess I'm confused as to, all right, if you parse it the way you do, a person in your, assume that the facts are as the Commonwealth alleges here and proved. So a person illegally is prescribing drugs to a drug addict, but by definition, because he's prescribing to a drug addict, he cannot be convicted of a crime. That makes no sense.
It's not that he's a drug addict, and it's not that he can't be convicted of a crime. It's the specific crime of dispensing, that it's a different crime. He may be convicted of any number of crimes, including distributing.
So what would be covered under your definition?
Well, for
An
instance,
example.
in Commons, the court
what?
upheld and said these police officers are ultimate users. Their possession is lawful.
Lawful. But other than that, so the statute will only cover buys by undercover police officers?
No, not
Oh, it's
only
for
covering
doctors
police officers. As I said, also in the patient in Commonwealth versus Coburn, there's no indication that he did anything wrong. If they went to a doctor,
I took it that your argument was that this, in essence, looks at the dispenser, i.e., you can't dispense unless you are authorized to dispense. In other words, if you didn't have a license, if your license had expired or the Board of Legislation had suspended you, whatever it is, you can be held liable under the dispensing piece of the
that's
statute.
one example. You could, yes. But even if your license is valid, if you prescribe but not for a medical reason, but the person you prescribe to is in lawful possession, such as a police officer, such as a patient who has not misrepresented anything or been complicit in any scheme to divert drugs or sell them.
Well, give us a scenario. How would that play out if a patient who is not, who is a lawful user?
Yes.
How could a doctor with a valid license unlawfully dispense drugs to a patient who is a lawful user?
Well, the doctor may be doing it for what is not a valid medical reason, whereas the patient is not complicit at all.
Trying to kill the patient.
I could make up a lot of far-fetched things, but just to stay, it could be a situation where the patient is more manageable. Many mental patients, as Dr. Coburn was a psychiatrist,
So we're going to
more
get into...
docile.
So that, it's a crime to prescribe to somebody who you're trying to make more docile because that's not the least restrictive alternative? I mean,
No, please, Your Honor, I'm not a prosecutor. All I suggest is that there could be an instance where a doctor could be prosecuted because a prosecutor says, I can prove that you didn't do this for a medical reason.
But
Yet your patient is not complicit. And that's the point. I think if your patient has not misrepresented in an attempt to get and sell drugs, to divert them, if the patient hasn't done that, as for all I can tell, the Coburn patient did not, then this could be a dispensing case.
But here we know that the patients were drug users who were looking for access to drugs, illegal drugs.
Not illegal drugs.
Well,
I mean, they sought them by now, because they're drug addicts, there was much testimony at trial about this. Many drug addicts have legitimate needs for opiate-based medications. And this presents a problem to physicians. There was testimony that Dr. Brown, my client, was known as an easy hit.
Well, he didn't even examine some of the patients. He just wrote the prescriptions.
I don't think the evidence bears that out, Your Honor. There is testimony by other experts from records suggesting that they didn't think the examination was adequate, but I don't think there's any suggestion that it was, as in, for instance, there are a couple of federal cases that are cited within the Brown opinion from the lower court where these patients, it was just totally a scam. The doctor was in league. He would write them. They would sell them to the leader of the scam. But in Brown, Dr. Brown testified himself. Yes, he was aware that some of his patients had problems with substance abuse. Nevertheless, they also had legitimate needs for pain medication. Some of them were referred to other doctors who were aware that these medications.
I'm not going to read footnote 5 from the appeals court opinion, but you know what it says. And part of it, he failed to test one patient for drugs at all and tested 3 of them only after a visit from the Medicaid fraud control unit. There was testimony from a former receptionist that he could on average see 50 to 80 patients a day. When asked how many patients he saw, the defendant answered it can vary from 20 to 50, occasionally 70. That's footnote 5.
I am aware of that, Your Honor. And the testing that's referred to, though, is a urine analysis for what drugs are in their system. The patients that are seen during a day are not all new patients. So it's not a question of whether there was an adequate initial examination to see whether these medications were legitimately prescribed. Sometimes a follow-up visit, there might not be the same need for a physical examination, simply a consultation of how things are going, how this medication is worked out, any side effects, et cetera. So I think that was not settled at trial, that there was a clear example of a lack of examination or a deliberate prescribing.
Well, you know, let's get to the bottom line here. Is your argument, is your position that doctors ought to be able to prescribe drugs to to people who are drug addicts, and that if they're not considered the ultimate user, that the doctor cannot be charged with anything?
No, I've never argued anywhere that the doctor commits no crime. What I've argued is, and what I continue to argue here is, that dispensing is not the crime. Dispense is defined by statute. Justice Mills said, hey, look, this may be hyper-technical, but that's what the statute says. It's defined in the statute. It was interpreted in Commons. It was interpreted again in Perry. And it says the way you dispense is you prescribe to an ultimate user. That's somebody whose possession is lawful. If you haven't done that, you can still be charged with distributing.
We're trying to get at what your interpretation of the statute is, what it was intended to proscribe. And as I understand it, and maybe I'm wrong, you're saying that it was intended to prohibit somebody like Dr. Coburn.
Commons quotes and says in a footnote what the purpose of the dispensing prohibition is. Justice Mills quotes that also in the appeals court opinion. Coburn is another example, in my opinion, of a patient who was not complicit, no wrongdoing on his part. He would be a lawful possessor. So maybe dispensing could apply there. But I've never argued that a doctor who prescribes without a medical purpose couldn't be charged with a crime. It's just that I think that distributing is probably the crime, and that maybe the Commonwealth took the wrong fork in the road. But the fact is that only dispensing went to the jury, not distributing. And if that was a mistake, that's the fact now. One was directed out.
Mr. Redgate, under this statute, under the statute under which your client was prosecuted, if a doctor legitimately prescribes a controlled substance to a person who is legitimately entitled to a prescription for that particular substance, the doctor's committed a crime. He has dispensed medication to an ultimate user.
But he hasn't unlawfully dispensed.
Well, how do you do it unlawfully?
You do it unlawfully if you do it not for a legitimate medical purpose.
Okay, so then Section 19 kicks in.
That's where you'd lose the exemption. It says if you do that, you're subject to the penalty.
It says because the prescription has to be valid.
You know, there are a lot of cases where this validity of the prescription is an issue of what that means. And for instance, this earlier version of Commons referred to a 72 amendment where dispensing applied only to a lawful order of a physician. That was stricken. So now the prescription may be lawful or unlawful. The question now for how you dispense has to do with the ultimate user, the endpoint, the patient, so if that patient's a lawful possessor, then you've dispensed. If not, and I suggest the evidence in this case is clear that many of these patients would not have been in lawful possession, then it's not dispensing. It may be distributing, but that was directed out.
Thank you, Mr. Lidgate. Mr.
Thank you, Your
Ogren.
Honor.
May it please the Court, Assistant Attorney General James Arguin.
Does Section 19A create a freestanding crime?
I think, Your Honor, the way to look at it, and what the Court did in Cummings, is that the crime is dispensing under Section 32. Section 19 is the means by which that crime is perpetrated.
But does Section 19 create a separate freestanding crime?
It could, but I think what it does is it refers to the penalties of dispensing. And the crime charged here, and that's what the appeals court focused on, and that appears in the appendix.
But it
pages
doesn't just
19.
refer to the penalties. It says you shall be penalized. If you do this, you shall be penalized.
That's right. And what I think it is it's setting, if you read the statute as a whole, what it does is set out the crime of dispensing, and this is what the Court said in Cummings and Pike, includes illegal prescribing to another person under Section 19. So Section 19 deals specifically with a subset of dispensing, specifically prescribing by a physician.
Mr. Ogren, I was with you all the way. It's just say that again.
I think dispensing, what the Court has said in Cummings and
I've got Cummings.
and Pike.
So where are we?
Well, they say what the Court said there is that dispensing includes illegal prescribing to another person, and the other person thing takes into account the Perry situation where the physician was just prescribing to himself. So it has to be to another person. And if you do it in a way that violates Section 19, and Section 19 says
Lawful person.
I'm sorry.
Lawful use.
Yes, Section 19 says of an order purporting to be a prescription that is not issued in the usual course of professional treatment is not a prescription, and it would subject the person to the penalties provided in Section 32 and all of the subsections to Section 32, and it specifically says as applicable. And I think that kind of limitation is important because it's clarifying and consistent with the definition of dispensing itself that appears in Section 1, because dispensing is there defined as to deliver a controlled substance to an ultimate user by a practitioner or pursuant to the order of a practitioner, and then specifically including the prescribing and administering of a controlled substance. And I think what defendant is doing is taking the definitional section of Section 1 and giving it extra emphasis more emphasis than it deserves, and taking away the true intent of the legislature in Sections 32 and Section 19.
I'm sorry, go ahead.
Are you suggesting then in the definition that the including language doesn't incorporate in the ultimate user part of the first part of that sentence?
I think if it's if the charge is illegal prescribing, the method by which the dispensing
Legal
is
or
done.
illegal, sorry. Legal?
Illegal.
Illegal,
Illegal
okay.
prescribing.
Yeah.
And that's the dispensing, then I don't think it's relevant whether it's an ultimate user. And I say that because, first, yes, that definition includes it, but also because Section 1's own definition of ultimate user says and its other definitions say that those definitions apply only unless the context otherwise requires. The context here, as this court said in Cummings and again in Pike, is that you've got to read Section 19 and Section 32 together. Because if you just read Section 32 without reference to Section 19, then any prescription, even those for a valid medical reason, could constitute an illegal dispensing.
Could
and
you
that's
have
not the law.
prosecuted this? Could you have prosecuted Dr. Brown for distribution?
Well, Cummings says no, and that's why the charge that was...
Where does Cummings say no?
Well, Cummings says that a physician who issues a prescription not intending to treat a patient's condition in the usual course of his professional practice of medicine does not issue a valid prescription, and he violates Section 32. And such a prescription violates Section 32.
But such a prescription is not a prescription.
Yes, and he says he
According to
violates
19.
it because it's in bad faith and for no legitimate medical purpose. And then in Pike, the court said that a prescription that's issued in bad faith for no legitimate medical purpose is a person who's guilty of dispensing.
But
In
what
both,
in what you just said says you couldn't charge him under distribution?
in Cummings, the charge was dispensing. The court suggested that that was the proper charge. Same in Pike. It was also dispensing.
But that was because they found the police, the ultimate users.
True. But the definition of dispensing deals specifically
lawful.
with a physician who issues a prescription, and then also, Section 19, for no legitimate medical purpose.
Well,
the proper charge is dispensing.
The problem that I'm having with your construction, when you read out the legitimate user, the ultimate user, in the lawful user in these circumstances, is that you could have a doctor who is prescribing medication for a patient who is a legitimate patient and in need of medication and is prescribing medication for not a legitimate medical purpose. He's a negligent doctor. He's committing malpractice. You're having him commit a crime.
No, because the bad faith requirement and for no legitimate medical purpose takes into account negligence. It must be specifically in bad faith. That's what the definition, that's what a definition in Section 19 is required to capture, to prevent just mere malpractice and negligence.
Well,
that's not
it
what
says
was
bad
intended.
faith in the sense that his purpose is not to treat the patient in accordance with accepted medical practice.
That's right.
And that's pretty much the definition of negligence. Right?
True, but you've got to show that it's outside the bounds of any professional practice, which is something that's not negligence. It requires that there's no legitimate purpose for it. That's the point of Section 19. And it also makes clear in Section 19, I should point out, that the whole focus of this is whether the patient said something wrong or did something wrong, of which there's no evidence here, is really misguided. Because Section 19, the second paragraph, the second sentence of Section 19 makes clear that it's the physician's obligation, not the patient's obligation, to ensure that there is a legitimate medical purpose. And I think the focus of ultimate user, even if that were relevant here, is similar to the approach this court took in Cummins, where it looked at whether or not a law enforcement officer who was acting in an undercover capacity could be a ultimate user.
So you're really saying pay no attention, really pay no attention to the definition of ultimate user here. Go up to the because in context, it clearly doesn't mean what it's defined to mean. Is that what you're saying?
Essentially, yeah. I think Section 19 is really the operative, as this Court has said, is the elements of the crime of dispensing when it's issued by a physician who's issuing a prescription for no legitimate medical purpose. Those elements are set forth in Section 19. The manner in which that crime is carried out is dispensing under Section 32. In the context of this proceeding, where there's indisputably a prescription that's issued by a practitioner to a patient for no legitimate medical reason, there's no reason to even address the question of ultimate user. It is a patient.
Except the whole definition of dispensing is the key operative phrase, is to deliver something, to a controlled substance, to an ultimate user. I mean, that's the
true.
definition.
And it specifically goes on to say, including the prescribing and administering of a controlled substance.
Yes,
so it
so
identifies
dispensing
that.
is prescribing. So you couldn't prosecute this case under distribution, because distribution is
includes
not
specific-
dispensing. So dispensing is prescribing, and dispensing has to be to an ultimate user. Ultimate user is defined as someone who lawfully possesses a controlled substance. And what you're saying, as I take it, is pay no attention to that, because in context that couldn't possibly be the case.
That's true, and I think, though, the backup to that would be, even if it were relevant, I think there's no way to show that the patients in this case were not ultimate users, because they did unquestionably get a prescription. They were presented as patients. They were examined by the physician or given a prescription for medication by the physician. Unless and until that prescription was shown to be unlawful, they were in lawful possession of it.
Isn't that your burden, however, to demonstrate that they're lawfully in possession? Isn't that an element here?
No, it's not, because the crime is under Section 19. I mean, the crime is, for when the physician issues it, it's just a question of whether it was done for a legitimate medical purpose or in bad faith. That's the essence of the crime of illegal prescribing, which I should note, that is exactly what he was charged with. The indictments that appear in the appendix, page 19 to 28, charge illegal prescribing of Class B and Class C controlled substances. They then go on to say, in the description of the offenses and the specified dates, that he did knowingly and intentionally dispense those substances to a patient in violation of Section 94C, Sections 32A and others, Section 32B.
At trial, what was the evidence, if any, about the patients? I mean, I understand from the briefs that there were expert witnesses reading records and sort of saying what they said, but was there any evidence about individual patients and whether they were in league with the doctor or anything about that?
There was no testimony from the patients. It was all, as Your Honor indicated, medical records. What showed is that the patients presented as known drug abusers. They indicated that they were in pain. The records, are not uniform as to each individual, but what the doctor did was then prescribe them for no legitimate medical purpose. There's no indication to say, for instance, that they violated Section 33 and that they misrepresented any kind of fact or anything else.
That's what I'm wondering whether ultimate user, the definition, what it excludes as an ultimate user isn't these people, but something like either you stole the prescription from somebody else or you misrepresented various facts.
I think that's very likely. And I think the problem of defendant's focus on Section 33 here is to basically get himself out of the burden that Section 19 squarely places on the practitioner of ensuring that there's a legitimate medical purpose by saying basically these patients lied to me when the evidence presented was quite clear that there was no legitimate medical purpose for any of these prescriptions and that he did not practice in good faith in issuing these prescriptions. And that was amply supported by the evidence showing that they weren't even using the drugs, that he was prescribing for them, but he continued to prescribe for them, leading to the inference, of course, that they were distributing them through through other purchasers.
Judge Mills, in his dissent concurrence, speaks of Chapter 94C, Section 33B, which makes it illegal to obtain prescription by fraud from a practitioner. You're not saying that these patients obtained it by fraud.
Right.
I'm saying that there's no indication that these patients committed any fraud when they went to the defendant seeking prescriptions for pain and substance abuse.
So are you also saying that you could not have charged any of these patients with the illegal possession of a controlled substance?
They certainly were not charged, and to my knowledge, there's no...
I know they weren't, but my question is, could you have charged them?
As far as the records presented in the trial court, no, there's no basis for showing that they committed any kind of fraud or misleading statement.
Okay, so you're saying that they were lawful users then?
Yes, I believe they are.
But
I think
how are
on
they
their
lawful,
face.
how are they lawful users if they obtained the drugs knowing that they were going to have to give part of them back to the doctor?
That's
I
only
beg pardon.
one of
That's
one,
relevant
please.
to the jury waived
All right,
trial,
but,
Your Honor.
All right, but what about the others?
Well, and I should correct, the statute requires that they be in lawful possession, not lawful users. The ultimate user is a person who lawfully possesses a controlled substance for his or her own use. And as to that, I think the prescription itself, the prescription constitutes delivery of a controlled substance. The prescription itself renders them in lawful possession of the controlled substances unless and until it's shown otherwise, unless it's shown, for instance, that they violated Section 33. Or here, there's no legitimate medical purpose.
So that means that if I go to a doctor and say I'd like a controlled substance and give no reason for it, and I get a controlled substance, I'm a lawful user.
Because I believe
I'm in
you are.
lawful possession.
You're in lawful possession because if the doctor writes the prescription, Section 19 squarely places the burden on him to ensure, or her, to ensure that there's a legitimate medical purpose for writing that prescription. And that's exactly what this doctor did. He wrote prescriptions for no legitimate medical purpose. But they were prescriptions, and on their face, those prescriptions remain valid and lawful, and render the person who received those prescriptions in lawful possession of the controlled substances, and unless and until it's shown otherwise. And as far as the question of use, in the 7 patients who received these illegal prescriptions, all of them were intended or given to them in their name for their use, although it appears that some of them may have traded them off for other drugs or sold them on the market, which is precisely the purpose of the Controlled Substances Act, is to prevent that conversion of lawful distribution chains into illegal distribution chains.
So in
and
other
that's
words,
exactly what's pernicious about it.
But a defense in this case would be to, well, of course, here none of these persons were called as witnesses.
That's right.
Right.
What about Justice Cowen's question with respect to the, I know that's not the argument with respect to the jury waive one, but that's the same charge, right? In other words, she got the prescription knowing at the time that she wasn't going to use it but was going to give him back some, right?
Well, on the jury waive charge, the evidence was she used some for her own use and some was kicked back to the doctor. So it was the same scenario. They were still, at least some of the drugs were still intended for her use. And I think that's, and I should stress that this definition of ultimate user was addressed in Cummings, and there the court adopted a very, liberal interpretation of the meaning of that, reading it in conformity with the overall purpose of the statute, which is prevent illegal drugs from getting from legitimate distribution means to illegitimate distribution means.
Unless we accept your view that we should ignore the phrase ultimate user, the consequence of your analysis is that you cannot prosecute the doctor for dispensing and the patient for possessing, that you have to choose one or the other.
Right. Right.
Well, I'm not so sure. That's probably true, but it seems to me that you can have lawful possession unless it's shown otherwise. And it may very well be possible that, possession doesn't mean it has to be continuous. It's just for an instant. So when they receive the prescription, on its face, it remains valid, and I think it remains valid unless shown otherwise. Once it's shown otherwise, I think both the doctor can be charged with unlawful dispensing and the patient who receives that for no legitimate medical purpose, if, for instance, they lied or violated Section 33
They
or some
lied,
other
and
thing.
if the doctor believes him, he's not
Right,
guilty.
exactly.
But I
So I
take
don't think it's an either-or proposition. I think you've got to look at it in points in time, and that's what's unreasonable about defendant's interpretation, because it makes law enforcement basically be omniscient in terms of anticipating, what the purpose was behind the physician, what did the physician know when he prescribed it, what does this ultimate user intend to do with the drugs. None of those facts are going to be available when someone's stopped on the street with a prescription for controlled substances. It's going to take a further investigation, as it did in this case. And once that investigation...
I'm sorry, go ahead.
Oh, well, and I'm saying once that investigation reveals there's no legitimate medical purpose and the doctor did not fulfill his responsibilities in Section 19, that renders him, by the clear statutory language, subject to a charge of dispensing in violation of Section 32, which is exactly what was charged.
In order to make out a case for dispensing, do you have to show that controlled substances were delivered to somebody, to the patient?
Well, the prescription itself constitutes delivery.
That's
So
the delivery.
That's clearly the holding
So
of
you
Cummings.
don't have to prove, you don't have to have evidence that the person went to a pharmacy and had it filled
It
out.
certainly does not have to be filled. Delivery under the definitional section can be actual or constructive, and this court clearly said in Cummings that the prescribing itself constitutes delivery.
Mr. Ogwin, I take it, and sort of follow up to the colloquy that you and Justice Gans, Justice Botsford had, is if we agree with you that the recipients of the prescription were lawful possessors, we don't have to agree with the appeals court's majority or dissenting opinion.
No, I don't believe you do. I think
We
the
simply
appeals
say
court-
these people were lawful,
Yes.
and end of subject, because that's
That
consistent.
would be the end of it.
Because
Your
that is
Honor.
consistent with, I mean, the dissent starts from the proposition that they were not lawful possessors.
That's correct.
Right? So, because you're under the ultimate user definition under Section 1. So if we say, no, they were lawful, this is a rescript.
That's correct.
Okay.
And also, that is exactly the approach the court took in Cummings, and I think it's the same approach here.
And so we don't have to get into the majority opinion in the appeals court either.
No, I think the majority opinion was attempting to reconcile the court's prior statements.
No,
in
no, I
Cummings and
understand that.
Pike.
But they also assumed that.
They did, exactly. They
Okay.
did, exactly.
Thank you,
Unless
Mr.
there are no further questions, I'll rest on our brief.
Thank you.